Okay, hi everybody. Thanks to Bob Joseph for organizing this talk, inviting me to give this talk today. My name is Jeff Langlois. I'm an associate lawyer at JFK Law Corporation in Vancouver. Just a quick introduction to us. We are a firm of about 15 lawyers. We're based in Victoria and Vancouver, about half and half lawyers in each office. We practice principally in the area of Aboriginal law. Our client base is about 95% First Nations, principally BC, Alberta, Yukon, Northwest Territories, and we have a good litigation practice in Ontario as well. Today I'm going to be talking about the Peel River Watershed case, case of National Gun and others against Yukon. This is a very important case that came out at the start of December. The hearing was last summer and a little bit in the fall. I'll say right at the outset as a little bit of a disclaimer. I acted as counsel in this case, not for the main plaintiffs, but for intervener, the Goshen Tribal Council, which is a land claims organization based in the NWT, but who exercise rights within the Peel Watershed. So I really had a front row seat to all of this, but today I'm not speaking on behalf of my client. I'm here as a lawyer to discuss the public aspects of the sort of facts leading up to the case and then the case itself, and we'll discuss some of what the implications of the case are. So why does this case matter? I suppose if you're listening to this, you have some introduction to what the appeal is, but we'll discuss that in quite a bit of detail. This case is an important one for a few reasons. First, it's the first case that interprets obligations under the Yukon final agreements with First Nations relating to land use planning. Those agreements have a very detailed land use planning process set out in them, and this is the first case to really interpret what they mean. There's been one land use plan concluded in the Yukon, but Peel is the second. There's lots more to go. So this case is going to guide that process. Depending on what happens on Peel, in any event, both cases are going to decide how that process works. The second reason this case is important is it confirms, not for the first time, but it confirms again that processes that arise out of modern treaties have constitutional aspects to them, and the honor of the Crown is going to be involved when implementing those processes. Third, it clarifies modern treaty interpretation. And the fourth reason it's important, and maybe the most direct reason it's important, is that the Peel Watershed is a very large, ecologically significant area in Yukon. And this has been a very public and a very hot button issue in Yukon for some time. And for Canadians as a whole, it's a very important wilderness area. It's one of the largest intact wilderness areas. There's no permanent settlements in the area, as we'll discuss a little bit further on. This case has really become a battleground between First Nations and Yukon residents who want to see a higher degree of protection for that area, and the Yukon government, which is the current iteration of the Yukon government, I think anyways, is intent on opening it up to further development. Now, I don't comment right now on the desirability of each, but it's important because it's sort of the next round in this battleground. So what do I want to talk about today? First, I'm going to introduce the Peel River Watershed for those of you who don't know what it's comprised of and what its sort of unique features are. The second thing I'm going to talk about is the Yukon Land Connect Agreements. This case is in some ways, a very technical case. It's not about the Peel Watershed in any great detail. It is about the land use plan provisions in the Umbrella Final Agreement. So to understand why the case went the way it did, you need to understand first what those agreements set out, and then second, the next item I want to talk about is how did land use planning for the Peel actually unfold? Because it's those circumstances that really drive Justice Vale's decision in the case. Next, I'm going to talk about the case itself, the arguments presented by the parties to the decision, and the order given by Justice Vale, and then we'll discuss briefly the appeal that Yukon has initiated fairly recently, just around New Year 2014. I'll end the talk off with a brief talk about what I think are some of the implications of the decision, and we can handle any questions that might come up as well. So first, Peel River Watershed. For those of you who don't know where it is, that's it there. It is the blue shaded area on the map. It is situated in sort of north-central Yukon. You'll see just north of that there is an area outlined in yellow. That's the North Yukon planning region I mentioned earlier. There's been one other land use planning, one of the land use plan that's been settled. That is the land use plan. Peel River Watershed was to be the second area to be settled. It's a very important area. Uh, Principally, it covers 6 major rivers, which feed into the Peel River, which in turn runs into the Mackenzie Delta. As I said, the area is one of the largest intact wilderness areas in North America. There's no permanent settlements, and for First Nations in the area, it forms critical habitat for the porcupine caribou herd, which really range over the North Yukon planning region into Alaska, into the Peel River watershed. And there are very important winter calving grounds in the Peel watershed itself. Now, ecologically, it's important. It's critical for First Nations as well. I'll go to the next slide here. This is the shape of the Peel watershed here, and the different shading you see are the different settlement areas granted under various land claims agreements to First Nations. I'll start in the top left corner. That is the Tetnikootchee or Naughty Yukon First Nation. They are based in NWT. There is a comprehensive land claim agreement between Canada and the Gwich'in Tribal Council, which administers various Gwich'in communities in the NWT. But that agreement grants settlement settlement area within the Peel watershed. There's 2 areas, the primary and secondary use area. You'll see a very dark shading there. Those are fee simple lands that are held by the Gwich'in Tribal Council within the Peel watershed. The other 3 maps are the settlement areas for Yukon First Nation. So you see the First Nation of Machinacum has almost total overlap with the Peel watershed, their settlement area. Untitled is a very large area. Untitled is a smaller area. They didn't participate in this litigation, but Machinacum and Untitled are the 2 principal plaintiffs in this litigation. It's a very important area for all of these First Nations. And what my clients say, so that's the technical in the top left map, is that this is the area they really go to be Gwich'in. They do a lot of traditional hunting, gathering. While there's no permanent settlements, there are camps throughout the area. And there are very important sites in here that really enable the exercise of what used to be Treaty 11 rights and are now rights under the Comprehensive Land Claim Agreement in NWT. So that's the Peel watershed itself, and the land use plan is to direct what kind of development can occur in this area. There's actually very little development that has occurred in the Peel watershed. There is an area that has been studied pretty extensively, and there's a lot of mineral and oil and gas potential in the area. There are lots of claims that have been staked in this area. While land use planning was going on, there was a moratorium on giving new claims. And really, the real key development issue, the real key land use planning issue here, it relates to the claims that have been given out already. There's lots of mineral claims that have been given out. The key debate in this land use planning process has been what kind of access can those holders of mineral claims have to their claims, and what might they be permitted to do in terms of developing those claims, including road access, including actually developing active mines or other exploratory work. Those are really the key issues that have come up with this land use planning. So Yukon land claims agreements. I'll back up and give a little bit of history here. Much of Canada, throughout the late 1800s, there were treaties signed between the Crown and First Nations. There was some treaty making in the north. Treaty 11, which is the last of a number of treaties, was signed in 1921 and covered much of the Mackenzie Delta, but largely did not cover areas in the Yukon. So throughout a lot of Canada, there are treaties that have been settled, and those have set down terms by which the relationship between First Nations and the Crown is to be governed. Grants or recognizes various rights of First Nations within these areas. But notable exceptions to this, Yukon and most of British Columbia had no treaties settled for various historical reasons. Treaty making really stopped around the 1920s and really did not resume again until the late 1970s. And that was really what made it resume again was a number of factors, but the most important ones I think were there were a lot of court cases in the 60s and 70s, well not a lot, but some very important cases in the 60s and 70s, which recognized that the First Nations who had not signed treaties with the Crown still possessed Aboriginal rights, including potentially title to lands where there had been no treaty. The next factor that really put the treaty-making process back on the table was, especially for the North, was an increased interest in development in the North. And I mean, the touchstone one is obviously the Mackenzie Valley Pipeline and Tom Berger's inquiry into that. The outcome from that inquiry was, well, there should really be a moratorium on big developments like this until we figure out what's going on in the North with First Nations. And really the message there was we need to have a new round of treaty making. So treaty making sort of began anew in Canada under the Comprehensive Land Claims Policy. Late 70s, there's agreements in Quebec for James Bay Creek. When you start getting into the 80s, there are lots of negotiations with NWT First Nations and Yukon First Nations. Those negotiations end with settled agreements in NWT, starting with the Inuvialuit, which Tribal Councils next in the very early 90s, Satu, Clucho, a variety of other land claims that have been settled there. In Yukon, the process was a little bit different. There was what was known as the Umbrella Final Agreement that was negotiated. That was essentially a template agreement, and then individual negotiations with individual First Nations in Yukon took place. Not all of the Yukon is subject to these land claims agreements, but there's a very large portion of it that is. And fundamentally, those are based on the Umbrella Final Agreement. These final agreements, they're very complex agreements, they're very long agreements. They're really intended to set out the relationship between Yukon First Nations and the Crown forever. These agreements have no expiry, and they set out a lot of provisions. Each of them, the Umbrella Final Agreement specifically grants settlement land. So there's a distinction between sort of settlement areas and settlement land. When I say settlement areas, what I mean is the area over which the treaty applies. Settlement lands are, the best way to think about them, are sort of individual lands that individual First Nations own in fee simple. And the agreement sets out various rights that First Nations have to settlement lands and settlement areas. There's compensation provisions, self-government provisions, there's the provision of resource rights, heritage protection, and there is the recognition of sort of what we usually think about as treaty rights. There's much more detailed provisions relating to those rights: hunting, fishing, trapping, rights to water, rights to access to land, rights to camp on lands. Those are all set out in these agreements in great detail. Importantly for this case, the Umbrella Final Agreement also contains a Chapter 11, which I'll discuss more in a moment, which provides for joint land use planning and management of lands and resources within the settlement areas. The other land claim I'll mention, just because this is what drove my involvement in the case of Yukon Transboundary Agreement. That is an appendix to the agreement with the Gwich'in Tribal Council and the NWT. Gwich'in's Comprehensive Land Claim Agreement sets out rights in the NWT. This appendix sets out a variety of rights, like I mentioned earlier, to the primary and secondary use area, to areas in Yukon. So in the Peel, you have an overlap of a number of rights. There's an overlap of First Nations in Yukon who have rights within the Peel. On top of that, you have rights of Gwich'in Tribal Council there as well. There's a number of sort of overlapping rights within the area. That Transboundary Agreement also provides the Gwich'in Tribal Council with the ability to participate in that land use planning process that's set out in the Umbrella Final Agreement, but not in this great detail. So Chapter 11, this is what really drives the case here. Chapter 11 was agreed to by First Nations in its government, and what it describes is the process by which land use plans will be developed for regions subject to final agreements. At a very high level, what was envisioned was an independent land use planning commission that would be set up. It would be composed of nominees of First Nations in the areas that the plans would be developed for, as well as nominees from government. the sorry, I'll back up here a little bit. Um, this provision is very detailed, and I'll get to the detail in a second. But when just to sort of forecast why this case might be very important in Yukon, these provisions are the exact same provisions that are going to apply in every other planning region, and the interpretation of these provisions is going to apply throughout. So before I get into the detail of it, you should know that these are going to apply not just in Peel, but throughout all the other planning regions. And now what this set out is this independent commission, and then what it envisioned was really sort of a six-step process. The commission was to be composed of those nominees, and then the commission was to go out in the world and study the Peel, talk to stakeholders, talk to First Nations, talk to government, talk to industry, talk to other interests in the area, tourist industry, concerned landowners, all these people, to figure out what are the interests in the region and what should we do as far as a plan with development going forward. That's sort of before the first step. They're supposed to go out and do this work. The first step is really that commission, the independent commission, comes back to the parties and says, here's a recommended plan. This is the result of our work. At that stage, Yukon, as well as Yukon First Nations, and I'll pause here a little bit on step 2. Once all the parties get that once they get that recommended plan, all the parties, government and First Nations, have the ability to approve, reject, or propose modifications to that recommended plan. Now, there's a parallel process going on here. Yukon has the ability to approve, reject, and modify the plan in respect to all of the lands in the settlement area that are not those individual settlement lands that I mentioned before. Yukon First Nations have the ability to approve, reject, and propose modifications to the plan in respect of the settlement lands which they obtained under those final agreements. I mentioned that detail, but all we really need to think about for this case is what Yukon's obligations are and what Yukon's powers are, because that's what this case turns on. Now, this case is a challenge to how Yukon exercises those powers. So upon receiving that recommended plan, Yukon can study it and say, we would like to either approve it, reject it, or propose modifications. If Yukon decides to reject or propose modifications to that plan, they have to provide written reasons to the commission. The fourth stage is the commission takes those written reasons and they take a look at their plan and they develop a final recommended plan and they provide written reasons to all the parties. So what this process envisioned was really an exchange of correspondence, an exchange of written reasons to start to develop a plan. There's competing interests in all of these plans, and this was to set out a very, I think, rational process to come to some compromises and to put some compromises in the hands of the independent commission and have them discuss those compromises. After the commission develops that final recommended plan, Yukon is then to consult with affected First Nations and other affected communities on the final plan. Then the last stage in it is Yukon under 11.6.3.2. Yukon is said to have the power to approve, reject, or modify that final recommended plan. So that's the broad structure. There is a recommendation that's made. There's a request by Yukon to either reject it or propose modifications. There's a new plan that is made, and then Yukon has the ability to approve, reject, or modify. This case is really about how is this actually, how closely did Yukon follow this, is really what this case turns on. What actually happened in talking about the Peel itself? The Land Use Planning Commission for the Peel was established in 2004. From 2004 to 2009, the commission went out and did that work, talked to stakeholders to try to develop this recommended plan. There's a lot of work, a lot of meetings throughout the region and beyond the region in Whitehorse and NWC to discuss what that plan should look like. 2009, the commission submitted that recommended plan to all of the parties. And here's what that plan looked like. This looks complex, but it's not very complex. This is the Peel. It's divided into various sub-regions. And what the commission recommended was the various land use designations. So those land use designations set out what kind of development could occur in that area. And the designations that they set out, these become simplified later, but I'll just explain them now. Everything that you see that's not yellow was really subject to some degree of protection. There were a variety in this first plan of what the Commission called special management areas that would place pretty heavy restrictions on the potential to development and access mineral claims in the future. So 80% of the region under the recommended plan was to be given these special management area designations, leaving about 20% of the region to be open for various kinds of development and access to mineral claims. From there, January 25th, the parties being First Nations, being Mechimaika, Chin, Chin, Fish Tribal Council, and Yukon, they all agreed on a process for consultations relating to the recommended plan. Basically, the whole of 2010 is dealing with how Yukon and First Nations are going to respond to this plan. Between the summer and the fall, Yukon consulted on the recommended plan, and what they came up with was a letter. In February of 2011, Yukon delivered a written response to the recommended plan. You remember they had at that point the power to approve, reject, or propose modifications. They did not choose to reject. They did not choose to approve. Instead, they said, "We'd like to propose some modifications for that plan." This is based around a letter of Minister Rubel, Patrick Rubel, who now actually works with the Land Use Planning, Yukon Land Use Planning Commission, not the Appeal Commission, but the overall commission. And what that letter set out was a number of that letter was really written in two parts. One was an appendix attached to that letter that had a lot of very detailed comments about typos, organization of the plan, and some very detailed comments. Then there's really a second part of that letter where the Yukon made and these aren't sort of my words, these are words that were used in the argument and ultimately made its way into the judgment of Justice Vale. They made a lot of sort of vague and non-specific requests for wanting more balance between development and protection of areas, and they wanted more options for access to existing mineral claims. These weren't set out in any great detail. The letter itself was only a matter of pages. The appendix was quite long, but the letter requesting these more balanced sort of comments, that's set out very briefly. Yukon First Nations and the Bush and Tribal Council, they also provided their comments. At that time, First Nations actually said 80% is not enough for us. We would like to see some more protection in certain parts of the appeal that have now been open to development. And then you remember, after receiving those written reasons, that the Commission was to take that back and develop a final recommended plan. That's what they did over the course of 2011. And in the summer of 2011, they released a final recommended plan. And that plan included written reasons for accepting or rejecting modifications proposed by the parties. And this is the final recommended plan. You see that the sort of color scheme has changed a little bit. Things have been simplified to a pretty great degree. There are a number of changes in here that responded to Yukon's the appendix and sort of simplified a lot of things, and a number of changes to the plan on that basis. But you'll see this plan does not reflect that those sort of higher level comments that Yukon gave about wanting more balance between development and protection. At a high level, it's still about an 80-20 mix. However, the Commission did make a pretty substantial change in how those special management areas were to be designated. In particular, there was a reduction in the amount of areas subject to special management designation that would last sort of indefinitely. What the Planning Commission did is say, well, okay, we've had a request that be more balanced in here. We think that Yukon has not really provided us very detailed comments on this, and we don't know how to sort of go back to the beginning of this process. We've heard a lot of conflicting evidence from a number of parties in relation to sort of what we should be doing with the appeal. But what they said is clear is that providing access to mineral claims and oil and gas claims in sensitive areas doesn't seem like it's an issue that can be resolved at this time. And this is really what the kicker was in all of this. First Nations said you can't provide access to existing mineral claims in areas that are, in a lot of areas in the appeal, because there's no such thing as temporary access in the field. Once you build a road, it's not like, say, in the southern part of Canada where you might build a road, if you don't maintain it year over year, that road goes away fairly quickly. Their evidence was in Yukon, there's no such thing as temporary access. Once you build a road, it's there for the long term. And once you put that road in, it opens up areas for other kinds of access. Even if even if you try to close that road down, that's not going to be policed that well. There's going to be a number of people accessing it to do more mineral staking and all of this within those areas. Commission also talked to industry about this, and what the commission said they heard from industry was that's largely true. There's no way to reclaim these roads in the short term. So if you put a road into a variety of these places within these green zones, you might be opening it up for a lot more access than you envision. So what the commission said in response to Yukon's request that there be more balance, they said, we can't do that, but what we'll do is this. We're going to divide these special management areas. We're going to create one that's 25% of the protected area that we're just going to designate as a wilderness area. And what that 25% will be comprised of is areas that could likely be subject to more development in the future, but our plan right now is pretty much a temporary moratorium on that development. It's subject to review, I believe they're subject to review in about 10 years after the plan came into effect. And what they said was this, they said, we can't come to a conclusion on this right now as to whether development can be done in a responsible and sustainable way, and that was really our mandate. And so what we want to do is to push this further down the road. More decisions can be made on this in the future, but for the time being, these are the protections we think are warranted given the work that we've done. So see, still a very plan that is very has a heavy mix of protection. There is areas open for development, but largely this is still about an 80-20 mix. So this case now turns on what Yukon did in response to the final recommended plan. So in October 2012, after studying that final recommended plan for some time, Yukon says to the world, now we want to consult with everybody, including First Nations, on the final plan for the peel. But what they did is they didn't bring the final recommended plan to everybody. What they did is they brought basically a brand new plan. And at the time that we're talking about here, the fall of 2012, there was just a series of 3 maps that were brought to the public, or sorry, 4 maps. One map was a final recommended plan map. The other were 3 brand new maps with brand new land use designations. So Yukon actually discarded much of what the commission did. The commission set up these special management areas, wilderness areas, and the integrated management areas. Yukon went and developed brand new land use designations. And really, I think, developed a brand new land use planning philosophy. And I'm not going to comment on whether that philosophy is good or bad, but it was a very different philosophy, and I'll describe it briefly. The philosophy the Field Land Use Planning Commission really used was a very prescriptive philosophy. It was let's divide this area up and tell the world what development can and cannot be done in an area. Yukon's philosophy is a little bit more based on what has been described as sort of principles of active management, which says yes, okay, some types of development are allowed and not allowed in certain areas, but the more important feature of these active management plans is to say we're going to open up a lot more areas for development, but we're going to monitor it. We're going to actively manage the kind of development that goes in there. So it's in criticism of those kind of plans are that they can be much more permissive, and they depend on a very active assessment of the effects and cumulative effects of development going on in those areas. So instead of just saying, this is an area that's to be protected, an active management plan might say, yes, there's values to protect in that area, but we think we can get away with a couple kinds of development and then stop it at that point. Again, I don't comment on the goodness or the badness of that philosophy. I just note for right now, what was noted for the judge in this case was that's a very different philosophy than the final recommended plan included. This is really a case of Yukon at this point starting to draft its own plan instead of looking to the final recommended plan. Now, at this point, Yukon begins to consult with First Nations about their new plan, and the position the First Nations take is you can't rewrite the plan. We've got a process in Chapter 11 of our Land Claim Agreement that provides for the writing of that plan. What Yukon's powers are to approve, reject, or modify that plan according to the process. So there's actually not really much of any detailed discussions that go on between First Nations and Yukon during this period. There's really First Nations saying, no, you should be talking to us about the final recommended plan. Yukon says to First Nations, no, we think we can do this. It really ended in an impasse in January 2014 with First Nations, including the British Tribal Council, Yukon First Nations, saying, we don't think you're doing your process correctly here, and we don't like the plans that you're proposing. And Yukon pushed ahead. In January 2014, it adopted its own plan for the appeal over some First Nation objections. And this is the plan that Yukon put in place. So I'll just quickly flash the final recommended plan. Colors to pay attention to here are light green and dark green to extent. So this is the plan that Yukon put in place. And interestingly, it really turns the mix of development versus non-development on its head. Yukon's plan provided for 29% of the area to be really protected from development, those still remain dark green areas. It then allows 71% to be open to access to oil and gas and mineral development. Now, 27% of that are those integrated management areas. That's roughly what the final recommended plan had set out. It's a little bit more. But the big change here is they really carved out from the areas that the Planning Commission designated to be special management areas. They carved out these light green areas, which they kept coloring them light green, even though these are areas where there is development is permitted. There are more conditions on development than in the yellow and the white areas, but access to existing mineral claims is allowed. Subject to regulation, GSAB, all the other processes in Yukon, but at a high level, this is the kind of development that this plan envisions. So it's a very different plan than was put before Yukon at the final recommended plan stage and at the recommended plan stage. So very shortly after Yukon adopted this plan, two Yukon First Nations, like I mentioned, National and Trambek, as well as plaintiffs from CPAWS and Yukon Conservation Society and two individuals who are the executive directors of those organizations, launched a claim. Their argument was that the final agreement should be interpreted to prevent Yukon from choosing to really reject that final recommended plan after only choosing to propose modifications at the recommended plan stage. Their argument was that in discarding the plan recommended by the Commission, Yukon has really made that whole planning process set out in Chapter 11 of the final agreement, which is a constitutional document and has constitutional aspect, that they've really made that whole process meaningless. And have they really abided by the spirit and intent of that treaty? British Tribal Council acted as an intervener in this case, with granted permission by the court to do so. The submissions by the Tribal Council were that modern treaties should really be interpreted with the goal of reconciliation in mind. Like I mentioned before, these treaties are to last forever. They're to be the foundational documents that set up the relationship between all the parties. Yukon said, or rather, British Tribal Council put to the court that it doesn't serve reconciliation if Yukon is really allowed to go through the motions of a collaborative process, only to rewrite that plan unilaterally at the end of the day. British Tribal Council put to the court that the Honour of the Crown is always engaged in applying and implementing these modern treaties, and that the Honour of the Crown is not served by the sort of very sharp dealing that it said Yukon had really conducted in this case. Yukon's argument in response was that Yukon retains the final say for what land use plan applies on the non-settlement land, and that a plain language interpretation of the final agreements permitted Yukon to adopt its own plan to appeal. If you remember, at that final stage, Yukon is said to have the ability to approve, reject, or modify the final recommended plan. Yukon wanted to read that very liberally. What they said was a plain language interpretation. They said, it means that we can approve, reject, or modify in any way that we like, after consultation with First Nations. So argument took place over the course of about a week. In July, there was another day of arguments in October. The judge called all the parties back. And and made his decision in pretty short order. From about mid-October to December, he took to write the decision. So it's a pretty quick decision. And what he held was that what Yukon did here in adopting its own plan was not in keeping with the spirit and intent of the Langlois Agreement, Chapter 11 specifically. But I'll go through a number of points he made in making his decision. He held that Langlois Agreement staff to be interpreted with a large, liberal, and contextual approach. And he said treaties are as much about building relationships as they are about the settlement of past grievances. He noted that land use planning processes derived from the treaty have a constitutional dimension, like I mentioned, that engages the honor of the crown. And Yukon has the obligation to respect solemn treaty obligations and promote reconciliation through the implementation of those treaty obligations. It's not enough, he said, to take a very plain language reading of this agreement and try to, essentially drive a bus through it. Is what I take from his decision. Yukon had the ability to approve, reject, modify, but he observed that that's within the context of this planning process. The planning process needs to be implemented in a meaningful way. He held that Yukon's interpretation of the agreement was inconsistent with the honor of the crown and the goal of reconciliation. And importantly, he held that by opting to modify the plan at the earlier stage, so you'll remember at the recommended plan stage, they did not choose to reject or approve, they choose to modify. He said that signaled a significant degree of approval of the recommended plan. What he held was that Yukon doesn't have to accept the recommendations of the commission, but they have to respect the process, and that process requires collaboration and consultation in developing plans. The question he raised, and these are key words, is viewed globally, has the land use planning process been respected and the purpose of reconciliation achieved? He held that it did not. He observed that Yukon was required to provide written reasons to request modifications to the recommended plan, and that modifications of the final recommended plan had to then be based on those earlier proposed modifications. What he held was that Yukon could not thwart the process entirely by imposing new modifications that the Commission had not been able to address. So this is really the crux of the argument. At the recommended plan stage, he held that the modifications proposed by Yukon were vague, were not a meaningful response, and could not then be later used by Yukon to say, well, look, we asked for more balance earlier, so that allows us to just draft a whole new plan and put in what we consider to be balance. What he concluded was the process followed by Yukon in really drafting a new plan after receiving the final recommended plan, it didn't enhance the goal of reconciliation and was an ungenerous interpretation not consistent with the honor and integrity of the crown. So what did he order? In this case, he ordered, or he made a declaration that Yukon had failed to act in conformity with the land use planning process. And he ordered that the final consultation, so that's the consultation after receiving the final recommended plan up into the adoption of Yukon's new plan, he said that whole process is squashed. He quashed Yukon's plan, which is to say dismissed both those processes. And his order was that Yukon essentially turn the clock back to the moment on which they received the final recommended plan, and that they redo final consultations on the basis of the final recommended plan. And he's got some details in his order here, which are important to understand. The main detail is this: he said, just pretend that we've turned the clock back to the final recommended plan. Yukon has received that plan. You're now to go and conduct final consultations on that plan. And you have the ability to approve that plan. You have the ability to propose modifications, but I'm going to tell you what modifications you can propose. It is only the modifications that were set out in detail in the letter of Minister Rubel in February 2011. So he said, if you have modifications proposed that arise directly from, and he specifies in his order which paragraphs of that letter they can do modifications based on. He says, what he said in his order is, you can do that, but you can't go beyond. You can't rely on a vague request for more balance to rewrite this plan. And importantly, in his decision, it's not a part of his order here, but as part of his decision, he said that Yukon does not have the ability to reject that final recommended plan at this time. He said that to reject that plan at this stage would, I think he's reading into his decision, that to reject a plan at this stage would not be consistent with the process that Yukon followed and that was set out in Chapter 11 of the final agreement. So a decision came out at the start of December. Yukon had 30 days to file an appeal. They did towards the very end of that period. Yukon's appealed a number of provisions of Justice Steele's order. They've appealed the declaration that they didn't comply with the process. They've appealed the order requiring further consultation. They've appealed the order that you can consult on the basis of the final recommended plan. Of interest, though, they have not appealed, and their notice of appeal, we've yet to see what happened, so this might change over time, but they have not appealed the quashing of Yukon's plan, which I think leads to a potential result that even if Yukon is successful in this appeal, and a court dismisses Justice Bale's decision, there's the potential that because they have not appealed from the quashing of their own plans, that there's just will be no plan for the appeal. And that if there is to be a plan, we're going to have to start this process all over again. So implications. I think the most sort of direct implications are if Yukon's appeal fails, I think there's likely to be an appeal to the SCC. I would say even if Yukon's appeal succeeds, I think we're probably on our way to the Supreme Court of Canada with this, based on the importance of the issues and what I've heard from counsel. Now, if the order is upheld at the Court of Appeal, and again, if the Supreme Court of Canada, if we go that route, I think that it's likely that a land use plan will have to be adopted that looks fundamentally like the final recommended plan. But it's important, I think, in just thinking about how this will work in the field. The land use plan itself is subject to amendment after certain time periods in certain areas. There are some areas that are set out as being protected for the very long term, and there's some areas set out as being protected only for I think about a period of about 10 years. But there are amendment provisions in this plan, and there will be the ability of Yukon and other parties to seek amendments to the plan at certain defined stages. So this case is not the end of this discussion about what to do with appeal. It's in some ways only setting up the latest sort of book of rules about how development will occur. But then that book of rules might well change within our lifetimes again. The sort of less direct implications are that there are going to certainly be implications for other land use planning processes in Yukon. As I mentioned, there's a whole bunch of land use plans that would yet to be developed. In the midst of this controversy, the Yukon Land Use Planning Commission has actually suspended to work on 2 of the plans to get some clarification about how these plans need to be developed, and then how government and First Nations need to respond and work through this process. So when we get some clarity through appeals, I would think, we will, the land use planning process in Yukon is going to need to abide by those. Broader implications of this decision, and again, subject to what happens on appeal, I think if this decision's upheld, it's going to be a very interesting precedent for First Nations to rely on, not just in Yukon, as most direct application, obviously, to those sections of the land use planning provisions. But there are First Nations in NWT, in Quebec, in British Columbia that are now becoming subject to these very detailed modern treaties. And a very large feature in these modern treaties is a sort of a delegation or the setting up of collaborative processes between government and First Nations to manage resources in the future. Some examples of these are resource management boards, land use planning, like we talked about, collaborative environmental assessment, really any process that envisions that governments and First Nations are going to get together in the future to make decisions about items. There are a lot of these in these modern land claims agreements, because remember, these agreements are supposed to last forever. They can't anticipate what's going to happen forever. And so what's been set up in a number of these agreements are other processes. I think this decision goes a long way to describing how these processes need to be respected principally by government. And I think this decision might act as a very interesting precedent for First Nations who are finding that the collaborative processes they agreed to in these land claims agreements are not living up to their expectations if they feel that government is not respecting the processes themselves. So this will be a very interesting appeal to watch as it goes forward. As I mentioned, Yukon's filed an appeal. Backlands are due sometime in March of 2015. There'll be a factum that's due from the Yukon First Nations about 30 days after that. I think the timeline for this appeal might be sometime, it might be heard as early as the summer. I would think, though, that it's going to be heard certainly before the end of 2015. So we'll get some more clarity on this decision as we go forward this year.